Hello everyone, welcome to the Supreme Court Observers channel. I'm Gauri Kashyap and today I'm joined by a very special guest, Justice S. Muralidhar, practicing senior advocate at the Supreme Court, formerly the Chief Justice of the High Court of Orissa. Today he's here with us as the editor and the curator of Incomplete Justice, the Supreme Court at 75. Welcome, sir. How are you doing today?
I'm doing fine.
We're so grateful that you can join us to discuss this book. The book, I'll just give a brief overview for our viewers. It's an anthology of essays by former judges, lawyers, scholars, researchers, and the various chapters engage with questions on the Supreme Court's evolving role and its functioning. So, my first question to you today is actually a question that we at the Supreme Court Observer often hear, which is people ask us, why do you have a platform dedicated specifically and solely in the study of the Supreme Court? And our answer often is that we found that there was a need to study the Supreme Court accurately and authentically to make it understandable to the people that it affects. So I wonder, when you set out to put the book together on overlooking 75 years of the court's journey, what were your motivations and what were you hoping to achieve with the book?
One is it's a court of record, and 75 years is definitely a milestone. So much happens in 75 years, and you see trends emerge. You want to know where the court began, how it progressed, and where it is at present. It's useful every now and then to have a review of what the court has done. And this is the court the orders of which are deeply relevant. It directly affects people, and increasingly that is being felt across the country. Just a Facebook post or somebody just getting picked up by the police, all kinds of things, even what we think is mundane daily affairs, of like organizing a protest outside, or an academic taking a lecture in a classroom. Everything can attract the law, the coercive element of the law. So you find today in the Supreme Court a large number of petitions of common people seeking protection of their life and liberty, of their freedom of expression. So increasingly, we need to understand how the court has come to where it is, what is the path that has been traveled. And it's a good time, I think, to review what the court has done. The second was that, largely all these commemorative volumes, you must have seen, centennial volumes, 50-year volumes, they largely are self-congratulatory. They're not really critical or reflective. They tend to be, basically saying what a good institution, whatever that institution has been. And even if you write about the judges, for a variety of reasons, people are usually hagiographic. They don't give us critical insights into either the judgments written by the judges or the judges themselves. We don't have a very vibrant critical legal studies movement in the country. Of course, there are some attempts being made through some kind of empirical data, but that's not really as rigorous as it should be. And the idea was to therefore get together scholars who are known to be a bit fearless and openly critical about the functioning of a court and of the judiciary. So even the choice of the authors was kind of informed by the positions they take, how objective they can be, and at the same time, are they in a position to critique the court's functioning? So the idea was to get a different kind of an insight into an institution's functioning. And that is what we sought to achieve through this book. It did not have to be confined to lawyers, judges, law researchers or academics. I also wanted to get other voices. Therefore, we requested Sainath, who is a veteran journalist, to give us his insights. And we also, as you have noticed, have 6 cartoonists who contributed 17 of their creative works. And that gives another, dimension to this whole book, which you may not find in other volumes. There have been books that use cartoons, but this was very carefully chosen so that it goes with the themes that the contributors have worked on. So the idea was to get a cross-sectional view of the court's working.
As you said, there are about 24 chapters now that are doing the work that you said, either empirically or substantively engaging with various aspects of the court, including the court and its actors, its impact on criminal law, equality jurisprudence, labor law, tax, etc. There's a variety of topics. One of the things that I wanted to focus on today was Rohan J. Alva's chapter on constitution benches. One of the trends he finds assessing that data is that between 1960 to 1970, there has been a flurry of constitution bench activity. The court was prolific in putting out constitution bench judgments, particularly in 1962, when as many as 175 constitution bench cases were decided. And he writes that this was at a time when there were just 14 judges at the top court. Now we have 34 judges, but constitution bench decisions are dwindling. In 2024, there were 12 constitution bench decisions. And so far, we're already at August, just one. In fact, we even know that the 2024 data is actually an inflection point if you look at the 10-year constitution bench decision data. So I wonder, what is this telling us about what the court's focus is? Is it veering off the path that it was initially set off on? And what can we do to have it engage in deeper questions of law, in substantive questions of law?
See, at a very practical level, and this is actually a logistic issue for a Chief Justice of India, the number of cases that the Supreme Court judges are having to handle has just gone up phenomenally. There's no comparison between what was happening in the first 20 years or even in the 70s to what is happening today. It's an explosion. Second, there is a centralization of many issues through PILs. Just take the forest cases or the pollution cases, the MC Mehta cases. So everyone is having to come to the Supreme Court through applications or petitions to have some of the issues decided. There are many cases where the court says no other court will handle this. Let's say the 2G scam, right? All challenges to orders passed by that special court had to come only to the Supreme Court. So for various pragmatic reasons, the court has taken upon itself far more things than it is able to handle. So the huge caseload means that a CJI, and still this is a very CJI-centric court on the administrative side. The CJI has to decide how many benches are available to deal with this growing, number of just fresh SLPs and after notice SLPs, and how many judges can he dedicate to constitution benches. And it's not just constitution benches. If there are two judgments of two judge benches that are contradicting each other, a three-judge bench is constituted. So there are even three-judge bench matters which are quite substantial in number. Now, if you have 34 judges and you have to have 5-judge benches and 3-judge benches, you could have them. It will mean that the backlog of those the 2-judge bench matters will go up. So it's the balancing of, how do you shift the load from one to the other. Having said this, I think a healthy practice was developed during the tenure of some of the CJIs to have at least one permanent constitution bench functioning. It has come in for criticism in the sense that the judges who are selected to be on the constitution bench, they're not done by rotation. Sometimes, like it happened in the tenure of Chief Justice Chandrachud, he was sitting on most of those constitution benches. So, which meant that he chooses the judges that will sit with him, and I don't know how democratic that choice of judges could be. So there is some misgiving on how some judges are completely kept out of constitution benches. But the fact remains that during his tenure, and you note in your question that in 2024 we had a larger number of constitution bench judgments than was there previously. That is because I think he was very determined that some of the backlog of the 9-judge bench matters, 7-judge bench matters must be cleared. And that's very commendable. So if a Chief Justice of India applies her or his mind to this issue, they can ensure that there is one permanent constitution bench functioning so that all the backlog of constitution bench matters is cleared. And it also will help in resolving many of these 3-judge bench matters, and more importantly, matters pending in the high courts, awaiting the judgment of this constitution bench. Because many high courts are often confused which judgment to follow. if they are of coordinate strength, judgments given by a bench of three judges, if there are two in number, which one should the High Court follow? I mean, by a rule of thumb, they say the later should be followed than the earlier, but that's not a very satisfactory way of resolving it. So it's very important to have this constitution bench, and since it's CJI centric, that CJI must be given sufficient time. And this is the third point I want to make. We've seen, CJIs have very short tenures. Justice Khanna had just 6 months. Justice Gawai is going to have only 6 months. Justice Suryakant will have 1 year and some.
But, yeah.
So during this period, you may not see constitution benches as many as you would like to. And then in between, there are matters, the fresh matters that come in. Like, let's say the present one, the advisory opinion. You have to dedicate 5 judges to it. There's a presidential election, a challenge to the presidential election. Under the rules of the Supreme Court, you have to have 5 judges sit to hear this. So all that also somewhere shifts the priority for the CGI. There's no easy solution. One is to increase again the number of judges in the Supreme Court. But every time you increase the number of judges, there is an inevitable decline in the quality of judgments. I don't know if this is part of your question, but this is something that we're able to observe as practitioners, because there's a greater chance of inconsistency between benches and some degree of indiscipline. I hope I've answered your question.
I want to refer to a point that you made on specifically of Chief Justice D.Y. Chandrachud and how he was present across all of the constitutional benches that he made. His predecessor, CJI Lalit, had a completely different approach. Even in that 75 or so day tenure, he had identified about 25 constitutional benches that will hear cases. And there we had seen a variety. Now, as you said rightly, it's a very CJI-centric approach. And when CJIs are changing in shorter tenures, what are we looking at some kind of guideline here that we can offer to, on how these constitutional benches are formulated? So it's not so changeable and malleable based on who the leadership is.
Yeah, we can't be rigid about these things. Let's say it's an issue on reservations. It must have, ultimately you want a representation on the bench. Just not representation of causes and constituencies in the Supreme Court, but even when certain issues are taken up, you need a proper representation on the bench. So let's say it's an issue concerning reservations. You have to be careful in which of the judges you choose to sit on that bench. And for a fact that, if you have a plurality of voices on the bench, it will help the dialogue on the bench. And it will be a healthy trend to develop even the law, accommodating all those conflicting points of view. If you choose only those who are likely to agree with you, then you're somewhere hindering that process. So why can't we rigid about this? I think one broad guideline could be that issue-wise and cause-wise, some care should be taken to see that there is adequate representation on the bench. Otherwise, it becomes problematic. Even when you choose judges to sit on the bench, do they come from different high courts? Because the approach to certain issues by certain high courts have differed over the years. And let's say there are 3 judges from a particular high court in the Supreme Court, and all 3 are there on the constitution bench, and only 2 from 2 other high courts. Again, there is not that plurality that one would like to see on the bench. So here, I think this has to be a very carefully thought out exercise. What I'm finding as a practitioner is, let's say the CJI is sitting with 2 judges, and the next court is a 2-judge bench court. He simply combines these 2 benches to form a constitution. So I always cite this, the Mirzapur Buffalo Traders Association case. The 7-judge bench was constituted to consider the correctness of the Hanif Qureshi case of Bihar. And ultimately, they overturned that judgment. This is on banning cow slaughter and what kinds of cattle can be allowed to be slaughtered and what cannot. And Gujarat had gone to the extent of saying no slaughter at all. And the Gujarat law was under challenge. So of the 7 judges who sat on the bench, which overturned Hanif Qureshi, 6 were vegetarians. So I'm just saying this, Could be just a coincidence. Somebody could argue, listen, I mean, there's no direct correlation between these things. But I think one must be careful in how that constitution benches. And also, there's this issue of subject matter bias. Judges may not want to admit it, but when you have interstate water dispute matters, you very often find, let's say it's a Kaveri water dispute. I've seen both judges from Karnataka and Tamil Nadu reluctant to be on that bench, and for good reason, right? So these kinds of things have to be kept in mind when you constitute benches. But it should be carefully thought out. You can't rigidify it. You can't say, oh, these things. But if you go through the development of the law, the practices earlier, there are pointers in this direction. And if you pay attention, you can get it right. The whole idea of the Supreme Court of India is the plurality of voices, right? Not to keep out, voices that may contradict yours. So as a CJI, if you only pick up people who will agree with you, there is a problem. And this is commented upon not just by Rohan here, but some other scholars in other writings. How even Justice Subbarao, when he became Chief Justice of India, he's one of the biggest dissenters, in the Supreme Court. But when he became CJI, he constituted benches of people who are likely to agree with him. So that marked shift happened. And therefore, I think the CJI himself or herself should not sit in every constitution bench. And there should be a kind of a rotation and a plurality of voices. And you can easily make that out. I mean, what is the inclination of every judge on certain issues, and you should let that come in.
I'll stay on the topic of constitution benches a little bit longer. This is to go back to Alva's point on the access and simplicity of constitution bench judgments. He makes 2 points. One is that there's multiplicity of opinions. So if there's a 5-judge bench, sometimes we see 5 different opinions, which sometimes makes it harder to understand what the decision really is or how the court is exactly engaged on, say, 4 or 5 issues that have been raised in that case. In fact, this is something that when we put up our judgment matrices at the Supreme Court Observer, we try and do that, which is put a tabular list of issues and against judges and what they've said. And we see those challenges. Sometimes they don't directly engage or it's a little bit unclear. And also we see that more and more judgments are getting longer and more verbose. I wonder if this, and we spoke about variety of voices here, and I wonder if this multiplicity is part of that healthy discourse, or if it's becoming counterproductive and just becoming verbose and maybe unreadable and ununderstandable to the general public.
See, I think I need to bring in the bar here because this doesn't happen in a vacuum. So before constitution benches, in the earlier days, arguments would go on for weeks on end and then supplemented by written submissions. Now, many benches have insisted that written submissions must be given in advance, written arguments be given in advance. And many of them are quite prolix, the written submissions themselves. Now, some of the judges feel it necessary to deal with every point that's been argued. Right. So if the lawyer is not clear, the judges not likely to be clearer. So it's a very difficult exercise given the time constraints and for the judges to be absolutely precise and clear. If you look at the Supreme Court of US, they deal with just 140 cases a year, and not even 80 are set down for oral hearing. And the number of judgments delivered are also, I think, are in the range of 100 or 150. And each judgment is worked upon thoroughly, drafts prepared, circulated. It's a lot of hard work even there. But it's a humongously more difficult work when it comes to Supreme Court of India. Just imagine on Mondays, Tuesdays, Mondays, Tuesdays, and Fridays, these judges are reading up to 65, 70 briefs. You're mentally very tired, right? And then you're hearing these matters on a Tuesday, Wednesday, maybe on a Friday afternoon, right? And then everybody's rushed through because no time. You would have found in the same-sex marriage hearing, 5 judges are sitting and there are some 20 counsel there and the judge is rationing the time. He says 5 minutes for you, 10 minutes for you and that kind of a thing. In rejoinder, you'll all get 2 minutes, 3 minutes. There's a cacophony of voices. And then when written submissions come, and I've been a judge myself, so I know written submissions can go into several volumes. And then some judges are very conscientious that everything has to be addressed. Everything has to be accounted for. That means length of judgments, the length just goes unmanageable. And there's bound to be some confusion if you go on doing this. He said that, no, A said 20 points, B said 20 points. And when you start dealing with it, there'll be some contradiction with some other judge. So the other judge who's been sent the draft needs time to read. Let me understand, let's, for instance, Justice Chandrachud was very prolix, very efficient, very hardworking. So let's say he sends his 300-page draft to the sister judge or brother judge, right? And that person has to react to it and prepare their dissent. That's not going to be an easy exercise. So if you prepare a dissent to a 300-page judgment, main judgment, it has to be as big or, probably bigger. And then for the ultimate reader, you get this plurality of opinions. So it's a lack of, actually, because of the lack of time, it's an ironical thing. Because of the lack of time, you're getting very prolix judgments. Because it's easy to dictate a very long judgment than to work on it and shorten it to become very precise and accurate. Like they say, writing a short story is far more difficult than writing a novel. Mm-hmm. So this is, and judges don't have that kind of a luxury of time to keep working, reworking a draft. So a combination of these factors are making judgments very long and sometimes confusing and self-contradictory. And I don't know an easy answer to this, but it can only mean that if the caseload really comes down, if you hear a case for, let's say, 8 days or 9 days continuously, I think all those judges who heard the case must be able to take off 3 or 4 weeks just to reflect on all that's been argued, every day to prepare some drafts, have conferences discussing those drafts so that I don't repeat what you're saying and you know what I'm saying. And if you can contribute to what I'm saying, then both of us can combine our judgments into one judgment. But that kind of time you need. Very often, some judges will tell you in conversations that no conference was held to exchange the points of view. Very often you will find a judge complaining that this draft was sent to me 2 days ago or last night, and you're compelling me to just sign along with you, and I'm not able to do that. And this has happened quite often, right from the Tulsiram Patel and earlier times. A judge is going to retire on a particular day. Like today is Wednesday, let's say Friday somebody is retiring. Today as a judge, you're getting, as a part of the bench, you're getting a draft and you're supposed to react to it. And the judge who's prepared the draft is retiring on a Friday. There have been instances of judges refusing to do this, that is the judges on the bench, and the matters having to be released from part heard because the presiding judge did not prepare the drafts till the last minute. So sometimes you have a judge of the Supreme Court retiring, leaving some 20, 30 matters like this. And all this is not spoken of in the public domain, but people should know that this manner of judgment writing is getting impacted by the caseload. And there's no easy answer till we reach a point where, the caseloads are handleable by judges.
I think that's why these kind of conversations are important, because from an outsider's perspective, it's easy to say, oh, justice delayed is justice denied. And, all of that, while very true, there is an operational part of a court and how it functions and how much caseload is there for us.
You'll be surprised to know one judge disclosed that the time the hearing starts, like today the case has started, right? He goes back to the chamber and starts dictating. Yeah. So you could say he's already made up his mind what he wants to do, right? But from his point of view, he's being very pragmatic. He delivers judgments within, a week of it being reserved. And some of us are quite, we're in admiration. Wow, here's an efficient judge who's able to deliver a judgment. There was a period in Supreme Court when 2 or 3 judges would give the maximum number of judgments. This judge would deliver, let's say, 200 judgments that year. And the next 10 judges or 12 judges together would not even give 200 judgments. And these 200 judgments are not of the highest quality. Some of these judgments will simply cite case law after case law after case law, have no reasoning but only a conclusion at the end of some 50 paragraphs. And this is a judgment of the Supreme Court of India. and we don't have that critical analysis of these things to make judges realize that, these kind of judgments are not reportable judgments because they're not advancing the law. They're not adding to our understanding. So I even say this, after 5 years or 10 years of becoming a judge, you fall into the trap of using certain stock phrases in your judgments. And your thinking, kind of becomes quite of, what I say, constricted. You're at a loss for words. Your writing can't be creative. Your English actually suffers a lot, right? The language that judges use. So every now and then I would wonder, whether I should go and take a course in English writing in good English, because you have a tendency to say, oh, this is that kind of a case. There's a whole pattern and some stock phrases that you use. Heart over heart as a judge that, you could have done a much, much better job. When somebody shows me a House of Lords judgment, a UK Supreme Court judgment, or a US Supreme Court judgment, I know if it's a far better quality, far superior quality to what I have produced. But I know within the time constraints that I have, this is all I can do. My target used to be at least one judgment a day, right? And let's say you have 22 working days. If I'm able to deliver 20 judgments a month, that's something as a High Court judge. But imagine what it really means. If you have to do complete justice to all the issues that were argued before you. And this is not counting those longish orders one dictates in the court. Disposing of by a 5-page or 10-page order, a longish order, or a judgment. This is apart from that, which is why judges have to, if you're a conscientious judge, there are no Saturdays, Sundays, no holidays. And most of them will go to, like one of those Nagpur judges or Bombay judges said, I go to bed at 2 a.m. every morning. He said it in an order, but the fact remains that some of these judges do that. And it's a tremendous pressure on oneself. You'll have somebody go tell the Supreme Court, the judgment has been reserved for 6 months. And which is a legitimate complaint, okay? Because I can't retain in my memory. You're expecting a judge to remember all the arguments of a case that was finally heard and reserved, let's say 1 month ago. And between that date and today, so many other cases have been heard, right? And some may be even more urgent than the case that was reserved. So there's a tendency to put that case off to the back burner. And then when you pick up that file or whatever, 4 months later, 5 months later, you have to come back to that position where you were when you heard the arguments. And if the written submissions don't reflect all those arguments, or imagine even worse, there are no written submissions. So some of the judges actually make quick notes on whether they had decided to allow or dismiss, because you may even forget that. So, you have review petitions saying, or you will have clients come and tell you, the judge was nodding every time my counsel argued, and he was in full agreement. And look at the judgment, it's exactly the opposite. So these processes of behind the scenes, how difficult it is to handle the caseload and, keep yourself alive and afresh. I think that's not talked about at all. And it's a mental strain for judges. This is not like producing cars. So they'll tell you, if you appoint this many more judges, you can deal with the pendency. It's not so easy at all. You need judges who have a mental capacity to hear cases continuously from 10:30 to 4:30 and to be able to deliver satisfying all the requirements, that every point that the lawyer argued has been dealt with, and you're giving a clear decision, and you're explaining the reasons why you agreed with A and disagreed with B on every point. As a single judge, I remember my frustration when I had written, I think, a 45-50 page judgment. This was in an arbitration matter, section 34, which is usually argued like a first appeal. When it went before the division bench, it got set aside and sent back to me saying you've not dealt with grounds K, P, and ZZ. Okay. So, it's so frustrating because you're bound to leave out some ground or the other. But the whole thing had to be, argued again for those 3 grounds and whatever that is. So it's a very tough task being a good judge. But there are good examples before us.
I think one relatable equivalent that I can draw for some of us who wouldn't know what it's like to be on the other side is to write, like you said, 20 working days 20 defensible research papers every day. Completely researched, edited, written, and then published.
No, and which can, the another frustrating thing is you work very hard on a judgment, and when it goes to Supreme Court, you get an order saying both counsel very fairly state that the impugned order can be set aside and remanded to the High Court. It's just setting at naught the whole exercise without any reasons being given. Only that counsel got up and conceded to some point. Yeah. Or they produce before the next court either a document that was so crucial, which they could not produce for some reason, and which completely changes the result of the case. So that's why, as a judge, you also develop a kind of an attitude saying, be thankful that there is some court above you to correct you. And today, I think the Supreme Court, they'll say, thank God for the curator petition. Somebody will bring a curator petition and correct my mistakes. All of this again stems from that first point I made. They're handling far too many more cases than the human mind can actually deal with. And we don't see how tired the mind gets. When you reach 3 o'clock, 3:30 point, many judges will tire. And they can't help it. There's a whole queue waiting there, lawyers, and some of the litigants so frustrated saying the same, Tariq per Tariq. So some judges become so insensitive. They say, however hard I work, it's not going to make a jot of a difference. I might as well relax. So which is why you find some judges suddenly get up at 3 o'clock and say, let's do the board discharged, right? The mental capacity for every judge varies. Now, and also this is emotional drain. Let's say I have an intense family court dispute, right? And then there's a custody of the child to be given, a 4-year-old child. And in the chamber, the child is weeping, saying that don't make me choose between my mother and my father. And as a judge, you have to deal with all that. So we don't account for this. We don't account for the emotional drain the judges go through. We don't account for the mental health of judges. And at all levels, I'm not talking just of the magistrate or the family court or the high court, even at the level of the Supreme Court, we don't know whether they have any, they're in a depression or they're overworked or they're emotionally drained. We don't know all this.
I just thinking about the issue that you're bringing out of backlog. Just before the interview, I checked up the numbers on pendency on the National Judicial Data Grid, and there are 87,445 cases.
This is the Supreme Court, yeah.
At the Supreme Court, that's right. And you interviewed Senior Advocate Meenakshi Arora and asked her about the cause of this debilitating backlog, and she had two primary reasons that she gave, which was one, that there is an inconsistency in the approach that each bench takes to admission of cases, and that there is no guideline to have a consistent approach across the 15 benches, 15 courtrooms. And the other thing she says is that benches seem to be questioning settled precedent at the drop of a hat. In fact, the incumbent Chief Justice, Justice B.R. Gavai, also said recently, he criticized that there was judicial impropriety when the Chief's bench recalls or stays or overturns an order of another bench, as if, among the benches there is some sort of hierarchy. But I wonder, has this inconsistency questioned the legitimacy of the court and public trust on the court?
No, and just that last part is not so difficult to answer. See, the fact that people keep coming to the courts, the filings have only gone up, not gone down. And everybody's coming to the court saying, where else do I go? Means that they still haven't lost hope in the court and they still trust them. Even in ordinary conversations that one has, I'm sure you've also heard this, they'll say we've completely given up hope on governments and legislatures, but judiciary, there is some hope. They're aware of all the controversies and how some judges are completely going astray. But as an institution, they still feel there's some place they can go to. And every now and then, some order, some judgment comes which affirms the faith, right? It might come a bit late, but it still comes. And so it gives hopes to others. So somewhere within this whole system with all its flaws, those glimmers of hope still exist. Like the public health system, you'll still have in the government hospital some doctors whom you respect enormously, right? Because they've seen a wide range of patients and they seem to get it right far better than in a private hospital, a doctor in a private hospital. Like that, among all the judges in the judiciary at all levels, there'll be some of them who get it right, not again all the time, but some of the time. So that hope and trust, I'm not sure, has completely eroded. And I must say that the present generation of lawyers are keeping that hope alive. I'm not definitely among those who says, the bar is finished and, there's a hope for the bar and all that. On the contrary, I think we're getting a good crop of young lawyers with a lot of commitment and idealism and hard work, prepared to do the hard work, prepared to take the knocks. That is very important. And not all of them want to work in corporate law firms. This is something that we all apprehended when the national law schools came, that the temptation is huge. Even now, I think 70% of them will naturally go to a paying corporate law firm or even a corporation, a company, which offers you, let's say, 2.5 lakhs a month. When you're 25 and 26-year-old, why would you not take that, right? But despite all that, we're still getting a good crop of youngsters at the trial courts and the high courts and the Supreme Court. I'm seeing that who are able to articulate, be confident, be unafraid. And that's a very healthy trend. So that part of it is fine. It is true, however, that there are far too many cases. The waiting times do increase, and your capacity to litigate varies. Mark Galanta came up with a study on one-shotters and repeat players. Right? State is always a repeat player. Right? It can keep coming back to the court till it gets an order in its favor. Yeah. Just let's see the governor's issue, right? Two judges of the Supreme Court have laid down timelines and said the governor can't sit on the bills. But the government's capacity to litigate is so high that it's able to get a presidential reference for 5 judges to sit and consider whether there can be different answers to those very questions. So the capacity of the government to litigate is enormous. The capacity of companies, some powerful corporations that you have, to litigate is very high compared to the individual litigant. So there is a lot of inequality that is reflected. Inequality in society is reflected in inequality among litigating capacity. And that is also distorting, what should happen, how cases should get prioritized. And so the answer is a bit mixed bag. If you're a litigant who does not have litigating capacity and very little resources, it's going to be still very, very frustrating, in the courts.
My next question is more process based, and it's arising out of your chapter on digitizing the judiciary.
Right.
We know that digitization, to a large extent, is not really new. It started in '96 with Chief Justice A.M. Ahmadi, right. But we saw a significant jump post-COVID. And so my question is, with that advancement, we've now gone to an era of data transparency, particularly, like I mentioned, through the National Judicial Data Grid, and the Supreme Court onboarded onto it in 2023. For our viewers, the National Judicial Data Grid is a live updated count on the number of cases filed, disposed, and pending at the Supreme Court and across high courts as well. Now, in your chapter, sir, you make the point that one of the challenges is collection of accurate data and live or immediate updation of that data. Sometimes when we log on to NJDG as well, we find that the data is either old, it's not been recently updated, and sometimes even inflated. We sometimes see, say, 50 Constitution Bench cases pending, and in the list we see that some of these are decided. We covered it just a few weeks ago. What is the path in this technological advancement that we're making in the court that we need to take so that we're able to collect data? Because without it, really, we can't have a healthy assessment of the court.
So this ties into a larger question on judicial administration. Very few viewers who are not in the legal field may be aware that we expect judges to combine in themselves several managerial qualities. Typically, a district judge has to be a manager of finance, manager of personnel, and manager of resources. He has to keep complete track of all the infrastructure projects happening in his district concerning courts. So suddenly, from being a judge who knows the law and who's able to hear witnesses, analyze the evidence, and deliver a judgment, you have to suddenly decide which of the 5 tenders is the best one to choose, right? Who's the reliable contractor, and which bills to clear, which bills not to clear, and how to recruit people, what kind of recruitment processes do you need. Everything now is in the hands of this one person called the district judge at the level of the districts. Right from hiring peons to stenographers to all kinds of cleaning agencies, So we have not trained these people for that. On top of it, we tell him, now, sir, computerization has come in, digitization has come in. You better keep track of what are the software glitches that you're likely to encounter, what are the hardware glitches you're likely to encounter. If you have very poor network connectivity, what to do. And suddenly he or she has got this whole bunch of things to deal with. And not just the district judge. Now you take it to the High Court. The CJ of that High Court will have these issues. So he or she will typically delegate it to a committee of judges. Now we are expecting that committee of judges to have all judges who are computer savvy. Right? Not all of them are computer savvy. It so happened in the Delhi High Court, I was very fortunate to sit with judges who were all computer savvy and a computer committee. So it was a peer learning. And that's the best way to learn. But this was not within our remit at all. So some judges would simply say, why am I doing all this? Because again, viewers may not realize, you get off the bench at 4:30 or 5. Within 10-15 minutes, you will be called into a committee room for a committee meeting. That meeting will go on till 7 o'clock. It can go anywhere from marking somebody's annual confidential roles to dealing with a complaint of sexual harassment against any of the employees or a vigilance case against one of them, or to deciding the question papers that one must set for the next judicial services exam. The whole range of issues which can't wait again. If you delay that, questions will be asked of you. That meeting can go until 7:30. And then you come back, you correct the daily days orders. So amidst all this, we expect judges, therefore, not only to be good judges, but also to get it right on all of this. So our failure to delegate these administrative tasks, including the tasks associated with digitization, means that judges are somehow to find both the energy and the ability to deal with these complex issues. So because I'd been in a computer committee for many years in the Delhi High Court, I could draw on that experience when I became Chief Justice of the Orissa High Court to say this will be the schedule, and I knew what kind of questions to ask and how to emphasize on this data gathering, data updation, ask for daily reports on uploading of orders. So court-wise, I had a whole chart prepared on how many orders were passed by that court and how many of those orders had been signed. Third column was how many of those signed orders were uploaded. And that put a pressure on the staff of the judge. Right? It can happen the judge is mentally so tired and he or she has dictated, 5-10 orders, and they want 2 days time to just revise those drafts, correct those spelling errors, because stenography is very poor at the level of the high courts. And that means that some bail order which should have been uploaded that very day doesn't get uploaded for 3 days, 4 days. And we're somehow depending on the efficiency not only of the judge, but of the steno of the judge, the secretary of the judge. So because as a Chief Justice I was keeping a tight leash, there was a better compliance. The minute a person like me moves on, it will go back to where it was. So many courts at all levels, whether it's district court, High Court, and sometimes even Supreme Court, there's a complaint that an order is not available on the net for more than a week. A judge has pronounced the order in court. The file hasn't moved to the copying branch for more than 10 days, 15 days. So there is something of this pressure of work, but there's something also of discipline. So since we don't do the regular updation of data at all levels, there is a mismatch between the data available on the National Judicial Data Grid and this. So one solution is to outsource all of this or delegate all of this. They can be sections of the judiciary, one section to deal with infrastructure, one to deal with computerization, one, and you can have dedicated personnel. So today what's happening is we are taking them all on contractual basis. Some courts are able to go ahead and some are not, because either the Chief Justice of that court gives a free hand to the computer committee of that court, which then is able to find the correct technical personnel and gives those technical personnel some freedom to do the best. So you will find that at one point Orissa was ahead, Kerala is ahead, right? So this inconsistent development in digitization, which is what I talk about in my chapter. So even though we had a system of court managers for over 20 years now, the way we've run it is very unsatisfactory. We're not professional. I can't make somebody a court manager because, he's under the recommendation made by somebody, right? We have to have actual recruitment, thorough recruitment procedures that are foolproof. And we should know how to get work done from them. Right? I can't simply have a court martial who's twiddling thumbs, doing nothing. And we fall back on our old habits of saying, who are you to tell me? I am the judge. You are no one to tell me that I should sign my order within 3 days. You're no one to tell me that I should upload my order the day I sign it. So, that kind of an attitude also is problematic. So we need to have more discussions amongst high courts, among judges, and somewhere we'll have to give away these tasks to other bodies and trust them to do it. We can have a broad oversight, but if we hold on to all the decisions regarding these matters to ourselves, and let me end with the E Committee of the Supreme Court, you're aware of that. Justice Lokur was heading it, Justice Chandrachud was heading it, but as a CJI, he did not bring in someone to head it. He held on to being the chairperson of the T committee. Now, as a CGI, you've got too many tasks in your hand. And if you don't delegate this task to someone else, that is bound to suffer. So you can see a visible slowing down of what the E committee has been able to do. Every now and then you will have an announcement of this scheme or that. But overall, in the entire judiciary, there's an uneven transformation from the physical to the digital mode. And that digital divide still exists. And within the Supreme Court itself, judges vary. Some judges will take to digitization, reading soft copies. Some judges will simply say, no, I will not go into digital mode at all. For me, I need my hard copies. And you can't blame them because you have not taken them in while making these decisions. So one of the suggestions I had, because I switched on to the digital mode, 2010 itself. One of the suggestions was that just like you have a law researcher for a judge, you could have a technical assistant for a judge. So the judge herself or himself does not have the scrolling on the screen, bookmarking and going to the right page. All these things irritate judges if they're not able to do that immediately. Or making the notes with a digital pen. Only by practice can you get it. And you need help for that. So there's much to be done. There's much to be done.
It might even make judgment writing easier at a later point if you have
it and I don't see any way out because much of our court infrastructure, when we plan for having more courtrooms and more record rooms. And the whole planning for a courtroom is those cupboards that you see stacked with files. I'm talking of district courts. Otherwise, all the corridors are filled with all those cupboards with files. All that can change if you go into the paperless mode.
Are we on that path for the Supreme Court?
No, so I won't be confidently able to tell you that we are on that path because there has been a kind of slowing down. Even in Orissa, where I was there for 2.5 years, and we made considerable progress in making many district courts paperless. Since there's been no constant push in that direction, it's like putting the foot off the pedal. You need to keep the foot on the pedal. You've started on some work and you have to see it through the end. But if a different Chief Justice comes who thinks, okay, this is not a priority, something else is a priority, then it will suffer. So it's happening at all levels. I'm talking of the Supreme Court where some judges now say there should be no live streaming. I don't want hybrid hearing. They actually tell counsel, you better come to court physically and argue. We don't want you arguing online. So if judge to judge there is a difference, then these things will suffer.
So, this brings me to my last question, which is you've been part of the legal system since the 80s, over 4 decades, in various capacities, from Chennai to Orissa to the Supreme Court now. And as part of working on this book, I think over 18 months, you've had conversations with lawyers, judges, many other people who studied the court now for decades. What is something that stood out to you in the process of editing, putting together this book? And what hopes do you have for the next leg of the court's?
No, so one thing that does worry me is the independence of the judiciary. And that comes through in all the conversations we've had, that judges are letting themselves come under pressure. And at the level of the Supreme Court, I would say even at the level of the high courts, judges need not come under pressure. If they're true to their constitutional oath, they should just ignore all the pressure points and send a firm message saying that don't mess with me. Right? But we're still not at that point. And that should happen from the top. Second, you don't pull up people for giving relief, right? Like a judge grants bail at the level of the district court, and you start questioning the motives of the judge. So there is a chill factor now across the judiciary, at least at the level of the district courts, and it's also percolated to the high courts, that some of these cases that arise under the PMLA, UAPA, all these special statutes, even the regular, I'm just saying a 376 or a 302 or whatever, getting bail has become next to impossible. So one big change I find in the Supreme Court is considerable number of cases are in the area of bails and anticipatory bails at the level of the Supreme Court. So in over the world, I think no other, Supreme Court, let's take the High Court of Australia, Supreme Court of Canada, they're not going to be dealing with an anticipatory bail petition at all. It's unheard of. And this is not what two judges of the Supreme Court are supposed to be sitting and doing, right? But that's the harsh truth of the matter because of this chill factor. So everybody is having to come to the Supreme Court for even those basic reliefs that you should be able to get at the level of a district court and the High Court, which means the time of the Supreme Court is being taken up with all of this, and they're not having real time to deal with those very serious issues that we started our conversation with, the Constitution bench judgments and this and that. So somewhere our priorities are getting determined by these factors. So how do we reverse this and correct this is a big challenge to us. And at different levels. So when we talk of independence of judiciary, it's not just independence of the judges of the Supreme Court or the High Court, but most importantly, independence of a judge who's sitting at the magistrate's court. How do we ensure that judge is able to function without fear of favor, affection, or ill will? And if we don't attend to this immediately, we can't really hope that judiciary will be able to deliver on the constitutional promise. So independence of judiciary is something that struck me and connected with that was all the life and liberty issues that we are talking of. And what we think is mundane is actually seriously threatening to somebody's life and liberty. Those two young girls in Palghar, in Maharashtra, just put a thumbs up, right, for a forward. And the police was knocking at their door and, taking them to police station. So we are at that level where, we need to assert as a judiciary, as an institution, and we need that confidence to be given by the Supreme Court judges to the high courts and the high courts to the district courts that please go ahead and do what you have to do without fear of, having a negative report about you in your annual confidential rolls or any inquiries being made about you. It's very important to give them that assurance. So this is one thing I would definitely say that emerged in the writing of the book. But on a positive side, I'm hopeful that the next generation of lawyers will be equal to some of these challenges and see that we stay on course. It's a huge challenge, but some of them are capable of taking on that challenge. And every now and then, despite all the bleak things that we say, we do find some judgment or some judge who, gives room for hope. And we need to see how to get more of those kind of judges onto the bench, for which we need more of those kind of lawyers. Lawyers who believe in the independence of the judiciary, lawyers who believe in fearless advocacy. So we need that.
That puts our conversation squarely in place because you call the book Critical Reflections. And I think hearing from you now, it's very clear that even critical reflections have to be couched in some contextual analysis on how things really work.
Yeah,
and so when criticizing to really understand what are the challenges that we're facing when trying to fix these little errors or larger errors that crop up in the judicial system. So, sir, I thank you very, very much for your time. Congratulations on the book. And I'd like to thank our viewers as well for watching. Please note that you'll be able to find two excerpts of the book, one on judicial delays and how that has affected some of the most important cases that are before the court, including the question of money bills being used to pass laws, as well as an excerpt on arbitration and whether judges make good arbitrators. So you'll be able to find both these excerpts on our website. Thank you all for watching. Thank you again, sir. And
Thank you, Gauri.
thank you. For more stories, conversations, and insights on the Supreme Court, please visit seobserver.in. Thank you.